18-Day Campaign Against Violence Against Women and Children is an annual international campaign that aims to raise awareness about the various forms of violence faced by women and children and to advocate for their rights and protection. This campaign begins on November 25th, which is the International Day of the Elimination of Violence Against Women, and ends on December 12th, which is the International Day of the Rights of the Child. Violence against women encompasses a wide range of abusive behaviors that are primarily targeted at women because of their gender. Over the next episodes, we will delve deeply into many issues related to violence and their impact, the many inspiring stories and practical steps towards a safer society. Together, let's raise our voices for change. This is 𝐕𝐢𝐴 and welcome to our 18-Day Campaign.
Important disclaimer. This podcast may contain content, language, and discussions that could be unsuitable for certain audiences. Listener discretion is advised. The views and opinions expressed by the hosts and guests are their own and do not necessarily reflect the views of the podcast platform. Parental guidance is recommended. Additionally, please be aware that this episode includes discussions about violence against women. A trigger warning is issued, and we encourage sensitive listeners to exercise caution. Thank you for understanding.
All right, welcome to our continuing 18-day campaign to end violence against women. And now we will have an overview of the Philippine Juvenile Justice and Welfare. So this involves two laws, Republic Act 9344 and Republic Act 10630. So, meron tayong mga frequently asked questions, no? Katulad ng, totoo bang makalusot ang mga batang gumagawa ng krimen dahil sa Pangilinan Law o yung tinatawag nating Republic Act number 9344 or the Juvenile Justice and Welfare Act? Sagot, hindi totoo. Bakit? Sa ilalim ng RA 10630 or an act strengthening the juvenile justice system in the Philippines, ang batang gumagawa ng malubhang krimen ay isa sa ilalim sa involuntary detention home o rehabilitation center sa loob ng 1 taon o higit pa. Tanong, totoo bang walang pananagutan ang mga batang 15 years old o pababa sa oras ng pagkasala? Sagot, walang pananagutang kriminal pero ang mga magulang ay may pananagutang sibil. Sa ilalim ng Section 20, Republic Act 10630, maaaring palayain ng batang 15 years old or below na nakasala at isa ilalim ito sa kustodiya ng magulang o tagapangalaga o kamag-anak. Sa ilalim din ng Section 20 ng RA 10630, ang batang 12 years old hanggang 15 years old ay idedeklarang neglected child sa ilalim ng Presidential Decree 603 at isa ilalim ito siya ng mandatory detainment kung ang mga krimen na ginawa ay alinman sa mga sumusunod. Parricide, murder, infanticide, kidnapping, serious illegal detention kung saan ang biktima ay pinatay o na-rape, robbery na may homicide o rape, destructive arson, rape, carnapping kung saan ang nagmamaneho ang nakasakay ay pinatay or na-rape, at paglabag sa ating Republic Act 9165 o Comprehensive Dangerous Drugs Act of 2002. So ano bang legal basis ng ating Republic Act 9344, ang tinatawag natin na Juvenile Justice and Welfare Act? It defines the juvenile justice and welfare system as a system dealing with children at risk and child in conflict with the law, which provides child-appropriate proceedings, including programs and services for prevention, diversion, rehabilitation, reintegration, and aftercare to ensure their normal growth and development. So instead of using the word juvenile, ang ating Philippine laws ngayon made use of the word child. No? As defined by Republic Act 9344, child is a person under the age of 18 years old. On the other hand, child at risk refers to a child who is vulnerable at the risk of committing criminal offenses because of personal, family, and social circumstances. Some of the examples mentioned in the law are being abandoned or neglected and living in a community with a high level of criminality or drug abuse. On the other hand, child in conflict with the law, or CICL, refers to a child who is alleged as, accused of, or adjudged as having committed an offense under Philippine laws. So a child can commit an act or omission, whether punishable under special laws or the amended revised penal code, which is referred to as an offense. Under Republic Act 10630, offenses which only apply to a child and not to adults are called status offenses. These shall not be considered as offenses and shall not be punished if committed by a child. Examples of status offenses include curfew violations, 301C, parental disobedience, and the like. Before RA number 39344 was enacted, children at risk and CICL were treated much like adult offenders when former President Ferdinand Marcos signed into law the Judiciary Reorganization Act of 1980, which abolished the Juvenile and Domestic Relations Courts. As such, child offenders were subjected to the same adversarial proceedings as their adult counterparts. So, bali ang turing ng batas noon ay ang mga children or child offenders ay para ring mga adults na rin. As an offshoot of the United Nations Convention on the Rights of the Child, UNCRC, Republic Act 9344, or the Pangilinan Law, intends to deal with these children without resorting to judicial proceedings. So instead of punishing juvenile offenders and treating them as criminals, these child offenders will be provided by the state and the community with assistance to prevent them from committing future offenses. The Philippines is a juvenile justice advocate. So RA number 9344 institutionalized the promotion of the well-being of child and their families, involvement of parents and guardians, promotion of diversion, avoiding deprivation of liberty, and protecting the privacy rights of children. RA number 10630 further emphasized child-sensitive justice policies focused on the best interest of the child. This principle has been first laid down in the Doha Declaration. So, what is the Philippine juvenile justice system? So, meron tayong diversion and intervention programs. So, the main features of RA number 9344 are the diversion and intervention programs. So, during the diversion process, the responsibility and treatment of CICL will be determined on the basis of his or her social, cultural, economic, psychological, or educational background without resorting to formal court proceedings. If the CICL is found to be responsible for an offense, he or she will be required to undergo diversion programs without resorting to formal court proceedings. During the intervention programs, on the other hand, they will undergo a series of activities to address issues that cause them to commit an offense. So this may take the form of counseling, skills training, and education. The bigger the role these diversion and intervention programs play in child behavior development, the more acceptance and social legitimacy these programs are likely to enjoy in solving problems with CICL. So Republic Act 9344 likewise raises the age of criminal responsibility from 9 years old under Presidential Decree 603 to a minimum of 15 years old. So before, the criminal age of responsibility under the revised penal code was 9 years old, and RA number 9344 raised this to 15 years old. So CICLs 15 years old and above are also exempted from criminal liability unless the prosecution proves that they acted with discernment. That is, the capacity to distinguish right from wrong. These child offenders are also afforded all the rights of a CICL until he or she is proven to be 18 years old or older under the presumption of minority rule. The age of criminal responsibility and the presumption of minority. In all proceedings, law enforcement officers, prosecutors, judges, and other government officials concerned are mandated to exert all efforts at determining the age of the CICL. The concept of restorative justice as opposed to retributive justice has also been introduced by RA number 9344. It espouses resolving conflicts with the maximum involvement of the victim, the offender, and the community. So this restorative justice primarily aims to achieve reparation for the victim, reconciliation of the offender, the offended, and the community, and enhancement of public safety. It also ensures that the child's rights will not be infringed when he/she admits to the offense. The Philippine Juvenile Justice System. So what is the treatment of children below the age of criminal responsibility? If it has been determined that the child taken in custody is 15 years old or below, the authority which shall have initial contact with the child in coordination with the local social welfare development officer or the LSWDO has the duty to immediately release the child to the custody of his or her parents or guardian, or in the absence thereof to the child's nearest relative. So ito yung isang controversial na provision kasi kapag 15 years old or below, dapat i-release tong nakahuli itong mga batang ito sa LSWDO or sa parents or sa guardian. Although na banggit natin kanina, yun sa mga malubhang mga krimen, sila ay i-detain at malalaman natin mamaya kung saan sila dapat i-detain. Ngayon, if the parents, the guardian, or other persons cannot be located or they refuse to take custody of the child, the CICL may be released to any of the following. First, a duly registered non-governmental or religious organization. Second, a barangay official or a member of the Barangay Council for the Protection of Children. The LSWDO or the Department of Social Welfare and Development, the DSWD, or authorities which have initial contact with the child, refer to law enforcement officers or private citizens apprehending or taking custody of the CICL. If the LSWDO determines that the child is abandoned, neglected, or abused by his parents, and the best interest of the child requires that he or she be placed in a youth care facility or bahay pag-asa, the child's parents or guardians shall execute a written authorization for the voluntary commitment of the child. But if there are no parents or guardians, or they will not execute it, the LSWDO or the DSWD shall file the proper petition for involuntary commitment. Only those who are at least 12 years old can be committed to a youth care facility. So what is the treatment of CICL depending on whether they acted with or without discernment? The social worker, using the discernment assessment tools developed by the DSWD, will come up with an initial assessment which is without prejudice to the preparation of a more comprehensive case study report. So the local social worker can either release or commit the child to a youth care facility if he or she is 15 years old or below, or above 15 but below 18 years old, but who acted without discernment. So alam natin ano yung discernment, yung pag-aalam ng what is right or wrong. However, if the child is above 15 years old but below 18 and who acted with discernment, diversion will be implemented. If the imposable penalty for the crime is not more than 6 years imprisonment, mediation, family conferencing, and conciliation or other indigenous modes of conflict resolution in consonance with restorative justice shall be facilitated by the law enforcement officer or punong barangay with the assistance of the LSWDO or members of the BCPC. Both the child and his family shall be present in these activities. In victimless crimes where the imposable penalty is not more than 6 years imprisonment, the LSWDO shall develop an appropriate diversion and rehabilitation program in coordination with the BCPC. Again, involvement of the child and his or her parents or guardians is a must. Ano itong iba pang system of diversion where the imposable penalty of the crime committed exceeds 6 years imprisonment? Diversion measures will only be directed by the courts. The diversion program shall cover sociocultural and psychological services for the child, which may include reparation of the damage caused, counseling, participation in available community-based programs, or in education, vocation, and livelihood skills programs. So kapag ang imposable penalty daw ng crime committed is lalagpas ng 6 years, ang diversion measures ay gagawin sa court. And it may include itong pagbabalik ng cost ng damage, counseling, at participation ng iba-ibang community-based programs, education, vocation, and livelihood skills programs. At the level of the appropriate court, in addition to the programs cited, diversion programs can also include reprimand, fine, or institutional care and custody. So pwedeng idagdag ng korte ang reprimand, fine, or institutional care and custody. So a diversion program will depend on the individual characteristics and peculiar circumstances of the CICL. So ano itong mga factors na to? The child's feelings of remorse, the ability of the parents or the guardians to supervise the victim's view, and the availability of community-based programs for rehabilitation and reintegration of the child. In case of failure to comply with the terms and conditions of the contract of diversion as certified by the LSWDO, the offended party can institute the appropriate legal action. So kung hindi daw nasusunod na itong diversion program, yung biktima ay pwede nang ipatuloy yung main na kaso. Also, if no diversion took place because the imposable penalty exceeds 6 years or the child or his or parents does not consent to diversion, the case shall be filed according to the regular process. So kung hindi matuloy ang diversion kasi lagpas ng 6 years or yung child or yung his or her parents hindi papayag sa diversion, the case will be filed according to the regular process. So yung pag-file sa city prosecutor's office, tapos magre-resolve siya, ipa-file sa court, warrant of arrest if need be, and the trial in the court. So where a child is detained, so meron tayong release on recognizance, the court shall order the release of the minor on bail or release on recognizance to his or her parents and other suitable person. So pwedeng makapagpiyansa or i-release lang sa responsible person like the parents or siguro yung mga taga-barangay. The court also has the option to transfer to the minor to a youth care facility. Meron tayong tinatawag na bahay pag-asa at iba pang mga rehabilitation center. And in no case daw shall the court order the detention of a child in a jail pending trial or hearing of his or her case. So hindi talaga sila ikukulong doon sa jail. Discharge of the child in conflict with the law when at the time of the commission of the offense, the child is under 18 years old and subsequently is found guilty of the offense charge, the court shall place the CICL under suspended sentence without need of application. So suspension of sentence shall still be applied even if he or she is more than 18 years old at the time of the pronouncement of his or her guilt. So ibig sabihin lang nito, hindi mo na isi-serve ng child yung kanyang sentence, no? Kapag under siya dito sa CICL law. Now, the court shall also impose the appropriate disposition measures in consideration of various circumstances of the CICL and upon recommendation of the social worker who has custody of the child, the court shall dismiss the case if it finds that the objectives of the disposition measures have been fulfilled. So, pwedeng i-recommend ng social worker na i-dismiss na yung case kapag sa tingin ng social worker na na-reform na yung child or hindi na siya magko-commit ng further offenses. Confinement of convicted children in agricultural camps and training facility. So dito sa Davao del Norte, meron tayong DAPICOL, no? So it is like a Bureau of Correction with a jail, at meron siyang agricultural camp, no? So nagtatrabaho sila sa farm, at I think meron pa nga silang sweldo doon, no? So the CICL, instead of confinement sa regular jail siguro or sa bahay pag-asa, pwede siya dito. Okay? Ang mga competent authority naman na nag-handle ng mga cases ng CICL are with the family courts. Kung wala naman po, doon po sa regional trial court sa mga lugar na wala pong family court. And so the Philippines institutional treatment of CICL under Republic Act 10630, or the Act strengthening the juvenile justice system, provided for the establishment of an intensive juvenile intervention and support center for children under the minimum age of criminal responsibility in Bahay Pag-asa. So while we end now, we will watch this video on the Juvenile Justice Welfare Council.
The Philippines, as a state party to the United Nations Convention on the Rights of the Child, is committed to uphold and protect the rights of every Filipino child. The enactment of Republic Act No. 9344, as amended by Republic Act No. 10630, or the Juvenile Justice and Welfare Act as amended, is a concrete action to achieve this goal. The law also established the Juvenile Justice and Welfare Council, JJWC. This law aims to protect and help children at risk and children in conflict with the law. It also emphasizes the role of children in nation building. The law keeps the best interest of children in mind and recognizes their rights to participation, development, survival, and protection, regardless of who they are and where they come from. The JJWC's role is to make sure that the law is fully implemented. They do this through policymaking, coordinating, and monitoring. Policymaking, creating policies and developing programs to help properly implement the law. Coordinating, forming effective communication among various government agencies, NGOs, and other partners involved that are part of making this law a reality. The ones that are key in reaching all the corners of the country so that no child is left behind. And monitoring, systematic collection of data and information and evaluation of the implementation of policies and programs through researches and maintenance of centralized database on children at risk and children in conflict with the law. The JJWC is also mandated to advise the President on all matters and policies relating to juvenile justice and welfare. It shall bring to the attention of the President the gaps in existing policies and other policy measures that should be addressed. Whenever appropriate, the JJWC shall recommend to the Congress the appropriate remedial legislation in regard to juvenile justice and welfare administration, juvenile intervention, delinquency prevention, and the mainstreaming and institutionalization of the principles of restorative justice. All these are also aligned with and aim to contribute to the achievement of the Sustainable Development Goals, SDGs. Ambisyon Natin 2040, the National Plan of Action for Children, and other national plans and programs for children. The JJWC also stresses the responsibility of its member agencies in ensuring the implementation of the law. Chaired by the Department of Social Welfare and Development, these key partners are To implement the JJWC is a collective effort. Supporting the Council at the national level is the JJWC Secretariat. And at the regions, are the Regional Juvenile Justice and Welfare Committees, RJJWCs, and its secretariats. The JJWC National Secretariat provides quality technical assistance along program development, policy formulation, advocacy, research, monitoring and evaluation focused on restorative justice to support the JJWC in performing its mandate. The JJWC Secretariat is composed of 4 divisions: Policy and Research, Advocacy and Communication, National Coordination, Monitoring and Information Management, and Finance and Administrative, headed by the Office of the Executive Director. In coordination with the JJWC Secretariat are the 17 regional secretariats supporting the RJJWCs. The Regional Juvenile Justice and Welfare Committee functions similarly to the JJWC, but on a regional level. The RJJWC is comprised of representatives from specific government agencies, as well as representatives from NGOs and children and youth sectors operating within the region. They are supported by the RJJWC Secretariat in performing its duties and functions effectively. In the end, the JJWC and RJJWCs work hand in hand with stakeholders and communities to establish a restorative system for children at risk and children in conflict with the law, and create an environment that these Filipino children can thrive in and feel protected.